Good evening to one and all. I welcome you all to the Jahangir Tutorials channel. If you haven't joined our Telegram group, please go ahead. The WhatsApp groups and the Telegram groups are given in the description. Go ahead and join that. There are a lot of revision series and lectures that are coming up. Now, also, it's a small request to all of you all. Do share the link of this lecture in all your WhatsApp groups and to all your friends, because today we are covering the most weighted chapter of your jurisprudence, that is your constitutional law. I will cover even the past exam questions which are there, okay, and all the details with respect to this chapter. So good to go. Am I audible and visible? Just once confirm in the chat box and we will start with this particular chapter. I just need one confirmation from you all that am I audible and visible. We'll quickly start with this chapter. Okay, so keep your books ready with you. Okay, you can make the markings. We will be discussing even the past exam questions with this. Great. Okay, so let's begin with the chapter. This chapter alone, it's a chapter marathon. When I say a chapter marathon, means I will cover one chapter in complete detail, okay, along with all the past exam questions. With me, I have my notes, which are also the same notes which you will find from your module. Second, I also have the past exam scanner with me. So for constitutional law, I will also take you all through the just past exam question, okay, of June 22 onwards as well. Okay, so let's start. First, the Constitution of India. Now the Constitution, the word itself comes from the meaning constitutes. When I say constitute, means it contains the basic rules, regulation, bylaws by which the entire country will be governed. So Constitution of India is a supreme law in India. It will contain the fundamental principles which are governed by the country. Now also I will be using certain keywords. You have to listen to it because in the same language you need to write in your paper. Okay, so I will focus on keywords as well. Now, when was the Constitution adopted? Okay, so first, very important dates. First is 26th November and 26th January. Both dates you need to know. First, on 26th November 1949, the Constituent Assembly of India adopted the Constitution, and it came into force and came into effect on January 26th, 1950. So two dates are important. First is your 26th November 1949 and second is your 26th Jan 1950. On 26th November, the Constitution was adopted and it came into effect with effect from 26 Jan 1950. And India, we celebrate these two dates. Both the dates are celebrated. First, we go to see 26th November is called as the Constitution Day, or the and also known as the National Law Day of India. It is celebrated on 26th November every year to commensurate the adoption of the Constitution, in memory of the adoption of the Constitution. Second, the 26th Jan is the Republic Day, is a public holiday when the country marks and celebrates the day on which the Constitution came into effect. Now both these dates, open your preamble of the Constitution. Both these dates are mentioned in your preamble of the Constitution. Okay, so on this date, we replaced the Government of India Act and we became a sovereign country separate from the British Raj, from the rule of the Britishers. So very good thing. Second, so the first part is you should know and you should quote in the exam when the Constitution was adopted. That's the Constitution Day. And second, when did the constitution come into effect? That is the Republic Day. Now, the first constitution of India. So I will talk about the first constitution in India. The first constitution of India was not a printed book. Instead, it was a handwritten book. It was a handwritten book. And it was written by Prem Bihari Narayan Raizada. Now, he was an Indian calligrapher to whom Jawaharlal Nehru approached and said that please write the first constitution of India. So, Raizada wrote the first constitution of India. Okay. When asked by Jawaharlal Nehru, what consideration do you want for writing the first constitution of India? He said, I don't want any amount. All I want is my name mentioned in the first constitution of India. So if you see in the first constitution of India, his name is mentioned and his signature is mentioned as a consideration for him writing the entire constitution for us. Now we go to the legislative history. I want you to take a screenshot and quote these in your exams as well. Okay. Now what is a legislative history? Or I could say the legislative framework. How many articles are there? How many parts the constitution is divided in? And all those parts. So the constitution contains 395 parts. Okay, 395 articles divided into 22 parts and 12 schedules. So this you can make a note. Now all of this is something where you can proactively quote in the exam. What are the past exam questions? When I come to it, I will tell you that this is a past exam question. So the Indian Constitution, the articles, there are around 395 articles in the Constitution. Now, which part of the Constitution is the most important that you need to mention in your exams? First is your part 3. Part 3 of the Constitution covers your fundamental rights. We all know the fundamental rights is the most important part in the Constitution. It's given in your part 3 from article number 12 to article number 35. Second, the fourth part is also very important. The fourth part talks about the directive principles of state policy, which are given in article 36 to 51. The directive principles of state policy are certain principles which the states must follow to achieve. So it is a broad framework. They have given you the most ideal principles, most ideal things that we want to achieve, and the states have to direct their policy to achieve these principles. Like for example, free education for all, a healthy environment for all, giving a better standard of living. These are all some of the principles that the states must try to achieve. Next is part 4 of the Constitution, 4A, which gives you the fundamental duties of the Constitution, given in article 51A. Now this is something, the past exam questions have been framed from these points mainly. Okay, so you can quote it in your exams. Next, if you go to see, another important point is you can read is emergency provision and the amendment of the Constitution under article 368. So at least part 3, 4 and 4A you should remember. Okay, now from here also you can take a screenshot. I will be taking you all through each and every article. Article 12, all of this, when I say article 3 is important, part 3 is important, all 13, 12, 13, 14, 15, 16, 17, 18. You can take a screenshot, you can learn it. I will be making you all do it in some time. Article 20, 19 to 22 and 23 and 24. So the questions have been asked from here. Okay, then you have your right to against exploitation, article 25, and right to religious freedom is given. Then your cultural rights, constitutional remedies, that's it. Okay, now the first part we start. Okay, now we've seen the Constitution when it was adopted. We've seen all the articles of the Constitution. Now we will start with the Constitution. Whenever you start and open the Constitution, you will find the preamble. A preamble is an introduction to the constitution. It contains the basic ideas, philosophies of the constitution. Okay, it throws lights on the aim and objects of the constitution. It is a key into the makers of the minds of the makers. Now, what is the significance of preamble? Significance of preamble is it's not just a brief introductory statement. Okay, if there is any confusion, ambiguity in the detailed constitution, that is in the entire constitution, any article number, we can refer to the preamble to interpret the meaning. So a preamble plays a very important role. It gives a window into the minds of the framers of the constitution. Okay. Now, if any provision of the constitution is not clear, the preamble can be used to clarify it. Okay, and now we will go through the preamble of the constitution as well. Okay, so it says, very simple, the preamble: we the people of India have solemnly resolved. So it is the people of India have resolved, have decided to make India, to constitute India into a sovereign, that is, we are supreme, there is nobody above us, no rulers above us; socialist, that is, we will work for the welfare of the society; secular, that is, we don't have any official religion of our own; democratic republic, that is, we will be a democracy, government of the people, by the people, for the people. Okay, and we will secure to all our citizens, that we will give to all our citizens justice, and justice of social, economic and political. Liberty is freedom, freedom of thought, expression, belief, faith and worship. Equality, equality in status and opportunity, and promote among ourselves fraternity. Fraternity is brotherhood. Okay, assuring the dignity of the individual and unity and integrity of India. In a constituent assembly on the 26th day of November 1949, do we hereby adopt and enact and give to ourselves this constitution. This, if you remember, in the start of the lecture I had told you a date, November 26th November 1949. Okay, so we celebrate the Constitution Day. Moving forward, okay, now moving forward, the words socialist and secular were added through the 42nd, and the fundamental duties were added in the 42nd amendment. These words were added. Now there are three important articles which I want you all to know from the part 3 of the Constitution, which is the most important. There are three important articles which have always been asked for more than 5 marks. Okay, so first is article number 14, then is article number 19, and then is article number 21. All these three articles are important, and they come in writing a detailed answer with case laws. So here we will discuss lot of case laws which you will remember and you can write in your exams. Okay, and the language. Now most of the times developing the language is very important. So I will be speaking and explaining you that language, so you will be able to write. Now what is article 14? Okay, in short, if we see what is article 14, so it talks about right to equality. Okay, so we say right to equality. Then if we see what is article number 19, so article 19 is right to freedom, and then comes article 21 is right to life. Out of these three, one article is a sure shot exam question. Now let's start with article number 14. Now we are seeing article number 14. Now first, article 14 says the state shall not deny to any person equality before law and equal protection of laws within the territory of India. So let's break it down. The state, the government will not deny to any person equality before law. Now what do you mean by the term equality before law? That everybody is equal in front of law. Nobody is superior. So equality before law means the absence of any special privilege. That it is not that if you commit a crime and someone else is got a immunity, they are got a privilege, so that will not be allowed. When I say equality before law means absence, that is there is no speciality or special privilege to anyone. So this is considered to be a negative statement or a negative language. That absence means there is nothing, so it's a negative statement. And when I say that negative means nobody will be given extra, nobody will be given special privilege. So this is equality before law. The second phrase talks about equal protection of the law. Equal protection of the law. So equal protection means this is a positive concept. This is a positive concept means you will be given something. So we are giving you, so it's a positive concept. Equal protection, that is equal remedy if the rights have been infringed. Okay. So negative concept means everyone is equal, nobody is above. Nobody is above. And equal protection means remedy will be given to you. So let's read it. Okay. First, the first phrase equality before law means the absence of any special privilege. That is irrespective of his rank, position, everyone will be subject to the jurisdiction of the ordinary courts. That is whatever is the powers of the normal courts, they all will be same treatment will be given. Next, if we go to see, second expression is equal protection. Now protection means your rights have been violated and you will get a proper remedy that anyone else would have also got the remedy in the same situation. Okay. So equal protection shall be secured to all the persons in enjoyment of their rights, privilege without any favoritism or criticism. If a person's rights have been infringed, they shall be getting equal remedy under law. So here is what I had said, that the former expression is a negative concept, that is implying absence of any special privilege, and the latter, that is equal protection of the law, is more of a positive concept, that is giving equal treatment to equal persons in equal circumstances. So this is the first part of the answer that you will write. Now the question is, does Article 14 apply to citizens only or even foreigners can claim this right? So when we go to see the article, how it says, the state shall not deny to any person. They have not used the word citizen. Whereas if you go in Article 19, they use the word citizens will get the following rights. So this is available to any person. So Article 14 applies to both citizens and non-citizens. Then comes reasonable classification. Today when I say of reasonable classification, it means that always there will not be equality. Sometimes we will have to give some special treatment. We will have to give some excess treatment to uplift the person. So reasonable classification means those who are equals will be treated with the same yardstick. But if there is a person is lower, let's say for example if there is an economically weaker section, so law will give them special privileges to make them equal. So to make equals of to make unequals equal, a reasonable classification is allowed. So the state, it states that those equals in the eyes of law should be treated equally. Equals are to be governed by the same laws, but regards to unequals, if there is a poor section, we cannot keep the same rules. We'll have to give them some benefit. So that is why in colleges there is a special quota made for the backward, for economically backward class. The same rules cannot be applied. In fact, those, if we treat the unequals with the equals, it will lead to inequality. If we treat the unequals with equals, it will be treated as inequality. So therefore we will allow some kind of segregation done. Okay. Then comes a very important line which they ask you to explain. So that is Article 14 forbids class legislation but does not forbid classification. Let's see what is the meaning of this. Article 14 forbids. Forbids means what? It prohibits class legislation. Now what do you mean by the term class legislation? Class legislation means making different laws for a different class without any lawful justification. So if I make a random law discriminating people, that is called as class legislation. That is not allowed. But it does not forbid reasonable classification. So classification can be done where you make a separate segment where we can see clearly that we need to give them some special benefits. So Article 14 envisages, now these are some words that you can use to build your answer. Envisages equality between equals. Those in the eyes of law should be treated equally. Okay. Now coming to the part where the Supreme Court has come in. The article prohibits class legislation but does not prohibit reasonable classification. This is done to bring the unequals among equals. Now very, very important, the case law which you need to quote. Okay. First, test of classification. So in the state of West Bengal versus Anwar Ali Sarkar, it is stated they give a test for classification. How do you determine that you can, this is fair, we can not have fair, etc. So I'll give you a few examples. For women, there is a separate, in the train there is a separate compartment, but for men there is no separate compartment. Now for the SC/ST there is a special reservation made, but for general category it is no reservations made. So what law says that, listen, we will have to decide whether this is lawful or not lawful. So for this they have said that when we are permitting any classification, it must satisfy two conditions. If we are allowing classification, two conditions it must satisfy. First, it must be founded on an intelligent differentia. It must be founded on a intelligent difference. For example, if I see the SC/ST and I see the general category, clearly a difference can be seen in their standard of living. I can make out that the general category is having such a luxury living, whereas the people who are from SC/ST have to work very hard and have been at a certain disadvantage in the society. So therefore a clear visible difference can be seen. So there is an intelligent difference that can be seen, a logical difference, distinguishing characteristic that can be seen. Second, for women, we've seen that women face a lot of safety issues. So therefore to protect women, we might have separate compartments, or for women have been, not been able to take up good places in the corporates because of the mindset of the people, where they don't allow women to work, etc. But now to uplift the women who have been, earlier by society put at a disadvantage, we can see a clear disadvantage that they are educating men, they are encouraging men will work, but for women in the earlier times, traditional times, they were not giving that much support. So now we need to give, we can see the visible difference. And there must be some logical sense, a nexus with the object to achieve the statute. Thus, it means that reasonable classification must be reasonable, fair, just, proper, and it must be in relation to a certain object trying to be achieved. For example, the object is to uplift women, object is to help the SC/ST, etc. Okay. So again, another case law is Ram Kishan Dalmia versus Justice Tendulkar. Okay. What it says, few principles and points they have brought down with respect to Article 14. First, Article 14 prohibits class legislation. That is, making a different law for different class of people, that is not allowed. We can, but classification is not forbidden, where we can make a small segregation that for this there is some difference. We can see we need to, this object we need to achieve. Permissible classification must satisfy two conditions: intelligent differentia and an object to achieve. Now, a mathematical accuracy cannot be achieved where we say that segregation should be done. With maths, you cannot show that this is there. A reasonable, understandable, popular sense can be used. Even a single individual may be treated by a class himself. For example, the President of India. Okay, the President of India. Now the President of India gets preferential treatment, gets a proper housing, gets a security, Z-class security, but for normal citizens we don't get. But we say, no, listen, he is the President of India, he is a separate class, and for him we can make a classification, and that is fair and just. Even a single individual can be treated differently. Okay. Now, Article 14 condemns discrimination not only on substantive law but also the law of procedure. This is also very important, which you can write. Discrimination will not be allowed in procedural law or in the substantive law. Now, what do you mean by the substantive law? Like the Contract Act, Companies Act, any act which is giving you powers, rights, duties, powers. What are the procedural laws? CRPC, CPC, all of that. So in any of the law, whether it is giving rights or it is taking you through a procedure, discrimination cannot be done. Okay. And if the law, if the constitution has given some kind of privilege to someone and it is challenged, if you read the recent judgments in the newspapers, it was highly criticized and challenged, where they were giving some extra reservations to the economically backward class, EBC. Okay, but Supreme Court has upheld it that it is a reasonable classification under Article 14. There is always a presumption in favor of constitutionality. That is, they will always presume that whatever law has been made is correct. And anyone who is going to attack has to show that there is a clear violation, transgression of the constitutional principles. Now, let's take a few examples and case laws also in the various Bahu versus Union of India. Now, in the Motor Vehicles Act, Sikhs have been exempted from wearing a helmet. Now, Sikhs, they have a turban, so therefore wearing the helmet is not possible. So as per the Motor Vehicles Act, the Sikhs were exempted from compulsory wearing a helmet. This was held that it is not violative of Article 14. Similarly, judges are given some protection, SC/ST women have been given certain protection, minority groups have been given some protection. All of that is fair and just. Now, this is a very important case law and it is also a past exam question. Okay, now what was the question? Pay attention. This was asked in the exam of June 2022. Okay, so now pay attention. In the case of Ranjan Ram Rajadan, Supreme Court held that for a valid classification there has to be a rational nexus there has to be for a valid classification, there has to be a proper nexus connection between the classification made by law and the object it is trying to achieve. A provision for the district wise distribution of seats of medical colleges on the basis of population of district was held to be void. So very important, that what happened is these are the different districts. So on basis of the population of the district, they wanted to distribute the medical seats. So they wanted to distribute the seats on basis of the population of the district. That is, if there is this much population, these many seats will be given. Here there is more population, so more will be given. Here more population, so more medical seats will be given. This was held that this is not based on some intelligent differentia and it is void. Okay, so I'll take you through the exam question also. This is of Constitution of India. This I have the scanners of all the exams. So here they had asked that the state in the Union of India made a provision for district wise distribution of seats in medical colleges on the basis of population. Decide the validity of the classification with the help of a recent case law. So as per the Ranjandran, the Supreme Court held that a valid classification on basis of the population dividing the medical seats is void. Okay, now coming to the next article, that is your article number 19. 3 articles I told you. One is a sure shot exam question. Okay, now your article number 19. Article 19 talks about right to freedom. There are 6 freedoms given to the citizens. One is Article 19(1)(a), right of freedom of speech and expression. You need to remember even the sub articles. Article 19(1)(a), right to freedom of speech and expression, right to assemble without arms, form associations, move freely, reside in any part of the country. Now F has been deleted, that is right to property has been deleted, and we have Article 19(1)(g) as a right to profess any religion, any profession. So speech and expression gives a right to speak and express yourself. If I can speak, then I can assemble with my friends also. So I have a right to assemble. After assembling, I want to form an association for XYZ. So I assembled and formed an association. After forming the association, I want to move freely throughout the territory of India. I can do that. Then I want to reside there. So that also I can do. And after residing, I want to do some business profession. So in this sequence, you can remember all the articles. Okay. Now, when they give you the rights, these freedoms are given. No freedom is absolute. It is always subject to some kind of restriction. So it is to be noted that none of these rights are absolute. Absolute means what? Without restriction, unconditional. I cannot speak whatever I want. Certain restrictions have been given. Each one we will go in detail. So the common restrictions that you can remember, the subject to reasonable restrictions. What are these reasonable restrictions? These are all common reasonable restrictions. So I cannot speak in a way that I will affect the sovereignty and integrity of India, security of India, friendly relations. I cannot affect public order, decency and morality. I cannot act indecent. I cannot amount to contempt of court. In court, you cannot go and speak anywhere. It will amount to contempt of court. I cannot speak bad about the Supreme Court in a manner which defames or brings down the reputation of the Supreme Court. I cannot defame, cannot speak false about anyone, and I cannot amount to incitement of an offense. That is, I cannot encourage anyone to do an offense. Okay, under the IPC. So these are the common restrictions. Now we'll go through each one of them. But for your exam point of view, the most important and the past exam questions also that they ask is from Article 19(1)(a. Article 19(1)(a) and Article 19(1)(g). That is your profession, freedom of speech and expression as well. Okay. So let's see. First, right to freedom of speech and expression. According to Article 19(1)(a), all the citizens have a right to freedom of speech and expression. So I can speak and express myself. It provides that freedom of speech and expression is a right to express one's opinion freely without any fear and I can express this through any oral means, through any written means, through any electronic means, any broadcast. I can broadcast my information and I can even express through press. Now I understand most of y'all know article freedom of speech and expression. But what to write within that article if it comes for 5 marks, that many don't know. So please make a note of the keywords when I'm saying that you are having a freedom of speech and expression. That means you can express yourself freely without any fear, and it could be through any mode: oral, written, electronic, broadcast or press. It includes right to make good or bad speeches, even a right not to speak. That means I can speak good also. Isn't necessary I have to speak always good about everyone. I also have a right to speak bad about people. If someone has harassed me, if someone is troubling me, I will actually speak bad about them. That's also fine, valid, lawful, truthful. Criticism is allowed. This right is available only to citizens. Very, very important. You read your Article 14 was available only to all, whereas Article 19 is available to only citizens. So here also you go to see all citizens shall have a right. So a foreigner cannot claim this right. Okay. No other person like a foreign national can claim this right. Now with every article where we saw in Article 1, Article Sub-Rule 2, this you can always quote in your exam. It always talks about the restrictions. So Article 19.1 talks about the rights. Article 19.2 talks about the restrictions on those rights. Okay. So Article 19.2, this at least you can quote. Right to freedom of speech is not unlimited, absolute. There are certain limits within which you may be restricted. Okay, it allows the legislature, that is the parliament, to impose some reasonable restriction on your freedom of speech and expression under the following grounds. As we discussed, sovereignty, integrity of India. I cannot speak anything which will bring disrepute to India. Security of India. I cannot go ahead and speak something which will go and affect the security of India. If imagine I am in the army and I go and tell what is there in the Official Secrets Act. I tell, well, the nuclear weapons are there. I will tell what is the strategy. It will affect the security of India. Friendly relations, public order, decency, morality, contempt of court, defamation and incitement of offense. Now when it comes in your exams, you need to quote some few landmark judgments with respect to freedom of speech and expression. Now what are those landmark judgments? Do you know? Can you give any 5 landmark judgments? So when in the exam that is asked, you should be loaded with case laws to write it. Now I will tell you, you can choose any one, okay, of them, any few of them you can do. First is Maneka Gandhi versus Union of India. Now what it was said in Maneka Gandhi case, that Maneka Gandhi, actually there was even in Article 21 that Maneka Gandhi versus Union of India was hit. So what happened is, she wanted to speak, she was against the government and she wanted to speak. So her passport was taken away and she was restricted to talk. She went into the Supreme Court and won the case. In the case they said that, listen, she has a right to move abroad also, you cannot take a passport. Second, she also has a right to express herself not only in India but also abroad. So sometimes we see a person wants to go abroad and freely express himself, criticize in a healthy manner. All of that is allowed. So freedom of speech and expression has no geographical limits, is what is given in the Maneka Gandhi case. A citizen carries with him this right wherever he goes. So a citizen carries with him these rights wherever he goes, is given in this case. The next is very, very important. Okay. Now we know which are the three pillars of the constitution. Which are the three pillars of constitution? Do you know? Three pillars of the constitution. So your legislative, your judiciary, your administrative. So all these are three pillars. But you know which is the fourth pillar of the Constitution of India? Fourth pillar, that is your press, media. Because that also is necessary in a healthy democracy. So freedom of speech and freedom of speech and expression also allows to speak and express in media, to put in the press, to criticize any politician, to criticize any act which is healthy. So press plays a very, this was an Indian Express case where it says the press plays a very significant role in the democratic machinery. The courts have a duty to uphold the freedom of press. So many times when you see when the press exercises too much, they have something called as kangaroo courts. Kangaroo courts are, they bring all these people on the panel and they decide this case which is already under trial in court. They'll call in the media channels and they will keep one side and other side and they argue. And in the end, the comparer will give the judgment. These are called as kangaroo courts. Ideally, this is discouraged to give media trials. But if you notice, still the courts will not intervene because they say that, listen, I understand, we will not try to restrict the press in speaking. It is our duty, it is a court's duty to uphold the freedom of press because that is the fourth pillar of the country. Next, if we see again Ramesh Thapar versus State of Madras. The freedom of speech, of expression and of the press laid at the foundation of all the democratic. Now this is again freedom of press only they are talking about. It is the foundation of all democratic organizations. That without free political discussion, no public education is possible. It has been decided at the Supreme Court that the freedom of press is an intrinsic part of freedom of speech and expression. So again, it's a case law. I will write that freedom of press is the foundation of all democratic organization and it is an intrinsic part of freedom of speech and expression. So these are some terms that I need to write and develop my vocabulary and my English. Okay. All democratic organizations, free from all discussions. Next we see Cricket Association versus the State Ministry of Broadcasting. So again they said that right to freedom of speech also includes to broadcast through audiovisual ways. So a cricket match can be relayed and it will be under Article 19(1). Next, very, very important case, a past exam question as well. And let me ask you the question. I want you all to give your judgment. There were some students who didn't want to sing the national anthem. So there were 3 students in a school. The national anthem were playing. Everyone stood up. Everyone was singing. But these 3 students did not sing the national anthem. They were rusticated. They were, removed from school. There was a temporary detention on them. The parents of the children went in the court, Supreme Court, and they said that the children have a right not to remain silent also under Article 19(1). So what are the children right or are the children wrong? I want your opinion. So in the case of national anthem, 3 students were expelled, removed from school for refusing to sing the national anthem. However, the children stood up in respect but were not singing. The validity of the expulsion of the removal was challenged by before the Supreme Court, and which had upheld the expulsion. So Kerala High Court had said yes, the expulsion is correct, they should sing the national anthem. However, when you go to the Supreme Court, the main guardian of your fundamental rights, the Supreme Court said that the students did not commit any offense. So very, very important, they can ask you in the exam that if these 3 students have not sung the national anthem, is it a violation of is it an offense? Answer is, it is not an offense. What has been held by the Supreme Court? The Supreme Court did not, that the students had not commit any offense. That there is no law under which their fundamental rights under Article 19(1)(a) could be curtailed. So again, freedom. So what was the main essence? It was that freedom of speech and expression also gives you the right to remain silent. So sometimes if before the police officer they are asking me certain questions, I have a right to remain silent, and that will also come under Article 19(1)(a) of speech and expression. So I can choose not to speak also. That's also my right. Then Tata Press versus MTNL, it has been held that commercial speech is a part of freedom of speech and expression guaranteed under 19(1)(a) and can also be subjected to reasonable restriction, only Article 19(2) and not otherwise. Very, very important that press or anyone can be restricted. So I know you all also know that right there should be reasonable restriction, but under which article it is given? So remember that the reasonable restrictions are given under Article 19 Sub-Rule 2. Okay. Then comes censorship. We all watch movies. Some of the parts of the movies get censored. Is that violation? Because the producer is saying that his rights are getting violated because that much clip is got cut. So is it allowed or not allowed? Censorship. So it has been said by the Supreme Court that censorship is coming under Article 19(2), which talks about restriction, reasonable restriction is allowed, and it was held in the case of K. Abbas versus Union of India. The censorship of films, including pre-sponsorship, is justified under Article 19(2) also. Okay. Then comes very, very important, I know, in not only in your constitution law, but also your Right to Information Act 2005. You can quote this case law. It's a landmark judgment which says that you have a right to speak and express yourself, but you also have a right, and you also have a right to receive that speech of someone else, receive information from someone else. So it has been said the right to freedom of speech and expression doesn't only mean that you will speak. It also means that you are allowed to receive information, because only when you receive information will you have knowledge to speak. Today, if I tell you to speak on the third law of thermodynamics, will you be able to speak? Because no knowledge, no speech. But if I tell you after my lecture speak on constitution, you will be able to speak. So even this when you're receiving this information, that is also covered under Article 19(1), and that is how the Right to Information Act was passed, and it derived its powers from the Article 19(1). So Right to Information Act derives its power from 19(1)(a), which states that only if a person gets information will he be able to speak and express his true beliefs. Then comes Article 9. So Article 19(1)(a), short they ask exam questions including case laws. I hope you're taking notes. Okay. Children has a right not to speak under Article 19(1)(a). Perfect. Next we see Article 19(1)(b), which talks about to assemble peaceful without arms. That is, I can have an assembly, I can have in a non-violent without disturbing the public peace. So that is allowed. It must be peaceful, it must be harmonious, it must be unarmed, and it should not come under the reasonable restrictions. Okay. Next, if we see freedom of association. Now, what is freedom of association? That all citizens have a right to make an association. Everyone has these, you must have a Rotaract club or a association of, cement manufacturers. You have WhatsApp groups. All these associations can be made. You have your cricket group, football groups, all those groups and associations can be made. Okay, now right to movement, so you can move in any part of the country as well. Okay, this right, however, does not extend to travel abroad except that you have a proper visa and the proper requirements. Right to residence, you can reside in any part of India. Okay, unless there are any territorial barriers. Now come to Article 19(1)(g). Now again I told you Article 19(1)(a) is important and Article 19(1)(g) is important. G is also important for what? Freedom of business and profession. And most case laws come from here only. Okay, and I will take you through some of the case laws. So any person has a right to profess any business or profession that he wants. Now let's see, provided there are certain restrictions. What are the restrictions? Certain professions require a certain qualification. If you want to become and practice in NCLT, you will have to get a license or you will have to become a company secretary. Only after clearing you can become a company secretary and sign as a CS. Or you will have to do your bar council exam to become a lawyer to appear in courts. To carry, okay, you can carry on by the state any business control. Now we're going to take certain case laws which they see of instances of reasonable restriction. Now again, these are important and also your past exam questions. Okay, now Nashwar versus State of Madhya Pradesh. The Supreme Court held that there was no fundamental right to carry on the trade in liquor because of public morality, public interest and harmful, dangerous character of liquor. Now, with respect to alcohol, the states, if they feel, they can put a reasonable restriction and make selling of liquor illegal. Can you all tell me in the chat box which state has banned selling of alcohol? Which state has banned the selling of alcohol? And whether that will be a violation of the fundamental rights? Answer is no, because very clearly in the Nashwar versus State of Madhya Pradesh, it says that there is no fundamental right that you can demand. If the state feels that in public interest they want to ban it, they can ban. And the answer is, which state has banned? Bihar. I'm not sure about Bihar, but I'm very sure about Kerala has also banned. Okay, great. I'm sure of Gujarat because I've been there. In alcohol is, and I don't drink and I don't advise, but I'm just saying that in Gujarat it is a place where alcohol has been completely banned. Okay. Now coming to the next one is State of Andhra Pradesh versus McDowell's. It was held that even if the trade in intoxicating liquor falls within the scope of Article 19(1)(g), the state could still impose severe restrictions, even prohibition on the trade of liquor intoxication. Now again, very, very simple and important. Again, with liquor only we are talking that the state can still impose severe and even prohibition and severe restrictions can be put. Okay, now this is again a past exam question. They have asked. Anyone who's studying the past exam question knows that this is a past repeatedly asked question. First, the Bombay Hawkers Union versus the Municipal Corporation, which had come for consideration before the Supreme Court. The provisions of the Municipal Corporation Act 1888 were challenged on the ground that the authorities were conferred arbitrary power. Arbitrary means what? Random, vague. Random power has been given to the authorities to grant and refuse licenses to hawkers on public street. So we see all these hawkers sitting on the road, selling their small goods. They get certain licenses, hawker licenses. Now the authorities were given excessive power to decide who to give and who not to give, up to them completely without logical sense. So then, and removing the unauthorized hawkers without giving them an opportunity of being heard. Now, they were allowed to remove the hawkers without giving an opportunity of being heard. So rejecting this, the Supreme Court observed that public streets are... So now again, are hawkers allowed and not allowed? So they are allowed to do business profession. Article 91G give them the right to do any business profession. So can they open on the streets? What do you think? What is it? So do they have a fundamental rights to do hawkers business on the road? Yes or no? Quickly. So the answer is no. Supreme Court said that there are no fundamental rights. No person has the fundamental rights to carry on any business which causes nuisance, annoyance, inconvenience to the public. And public streets are very definition meant for general use of public. If the hawkers sit on the public will not have place to walk. So remember, in Hawkers Association, the hawkers lost the case. They lost the case. It was therefore held that the BMC were under the nature of reasonable restrictions in the interest of general public, and it is not violative of Article 91G. Now we are going to see instances of unreasonable restriction. So something which was not fair. Now this is also a past exam question. I'll tell you the case, and it's a very famous case of Chintamani Rao versus State of Madhya Pradesh. Now what happened during agricultural season? There were very simple. There were BD, that is cigarettes that were being made, and there was agricultural business. Now obviously BD making, cigarette manufacturing was more lucrative, so all the farmers and the people started going into the BD making business. So what the state of Madhya Pradesh said that, listen, nobody is left to do agriculture. Then who will do agriculture? So then they said during season period, you cannot engage yourself in BD making. You have to compulsory do agriculture business only. Is this restriction and this law valid? What was the case? They said that the government prohibited manufacture of BDs during agricultural season. No person, then obviously the agricultural manufacturers, the BD manufacturers will say that our business will shut down. And the farmers also said that, see, listen, agricultural business is not that fruitful. We don't want to do, we want to get into this business. So the states were unfair and put an unjust law, and it was said that the prohibition was unreasonable. You cannot force someone to do agriculture business. The government should give good support, beneficial that people want to switch to agriculture. They cannot force that you can't do manufacturing business and have to mandatory do agricultural business. So in Chintamani Rao versus Madhya Pradesh, the Madhya Pradesh government lost, and it was held that the restriction imposed by them not to do agricultural or not to do manufacturing of BDs was invalid. Now coming to a constitutional provision relating to state monopoly. Now this is also very, very interesting, very, very interesting. Okay. Now when I say interesting means what? Okay. When I say interesting means what? Now you have a right to do business whichever you want as per Article 91G. But can I set up my own railways? Can I start a currency printing business? Now they say, wait a minute, business means anything, right? So they say, listen, if at all the state has monopoly to do business in something, then restricting you is fair. So we had seen in public transport, the government had monopoly. So they can declare that we have monopoly and nobody else can enter into this business. So let's read it. Creation of monopoly rights in favor of a body or a person, okay, affects the freedom of trade. If I give a monopoly, creation of a monopoly rights, if I make a monopoly right in favor of anyone, it will affect the freedom of others because you are giving monopoly right to someone. But in certain cases it is justified. When the states create a monopoly in its own favor, when the states create a monopoly in its own own favor without being called upon to justify in its action, are being action its court as being reasonable, and they can justify its action in court, then it is said that it is reasonable. In Article 19(6), it is clear that the freedom of business, profession, trade will not be understood to prevent the state from creating any monopoly in itself. So just because we've given you freedom of business, that doesn't mean that the state cannot create a monopoly of business in a particular segment, then you cannot do the business. If a law is passed creating a state monopoly, the court should inquire as to whether the provisions of the said law are being basically and essentially necessary for creating a state monopoly. So very, very simple. If the state has created a monopoly in its own favor to do a business, okay, so that time the courts will ask, the courts will inquire, will definitely ask that is it basic and necessary for creating a state monopoly? Because see, should the government enter in business? Should the government enter in business? Answer is no, leave it to the private sector. But in some sectors, the government takes monopoly. Only when it is essential and needed, it will enter. So it is absolutely allowed. Clear? And that is given in your Article 19(6). Now we come to the third and the most important article of the Constitution. Okay, that is your Article 21. This is again a past exam question, and it is also interview question where they ask that which is the most cherished right in the Constitution, which is the most cherished and the most important provision in the Constitution. So that is your right to life. Okay, so Article 19 is nothing but right to life. It covers all those things which is necessary to make life meaningful. To make life meaningful, like right to education, right to healthy environment, all that things that help you to live better is coming under Article 1921. So it is a wide right. Now let's read Article 21. Tell me one thing. Can we kill someone? Can we kill someone? Yes or no? I want you all to say. Can we kill someone? I want you all to answer, okay? Can we kill someone? Answer is absolutely you cannot, okay? You cannot kill someone. But if you notice, so many times we have, persons put hanged to death. So we are killing someone, right? But these are criminals who have been, after a proper court process, they have been killed. So what happens is they say that no person shall be deprived, that is of his life, should be taken away. Deprived means denied of his life, killed, except according to the procedure established by law. So procedure established by law means what? A proper court procedure was followed, CRPC was followed, he was taken in court, he was given a chance to defend himself, then the Supreme Court passed the order, and then he was declared that his life should be deprived or he should be killed. So that is allowed. So no person shall be deprived of his life, except means he can, if a proper procedure of law was followed. Or his personal liberty. Liberty means to move around freely. So no person shall be deprived of his life, that is killed, or if we jail someone for 3 years, he will be behind bars. So he will not have a right of liberty to move around. Okay, but liberty can also be done if a proper procedure of law was followed. Okay, now we will see liberty means what? Confining someone, to stop someone. Now in the case of Kharak Singh versus Uttar Pradesh, what was held that there was a person who was left on parole. A person who was left on parole to go to his house, and the police officer followed him. And he was looking into his house. The police officer followed him and was looking into his window what this accused was doing. So the accused filed a case in court that, see, he is affecting my right to privacy. Why he has to follow me? So it was held that the court held that there was a visit of invasion of privacy and therefore violative of personal liberty. Okay. So right to life includes right to privacy as well. Then comes the Maneka Gandhi, famous Maneka Gandhi case. What did they say? Again, first, that right to life also includes a right to go abroad. The right to go abroad. No person shall be deprived of this right except through a procedure established by law. Then again, Satwant Singh versus APO, it was held that the right to travel is included within the personal liberty and no person can be deprived except through a procedure established by law. Okay, and since a passport is essential for enjoyment of this right, denial of passport amounts to deprivation of this liberty. So you cannot just take away someone's passport. Okay, it can be done only through a proper procedure established by law and stated by the courts. Now when we say the word procedure established by law, okay, it means that a procedure is to be followed as given in your CRPC. Abroad, right to life, no person shall be deprived of his life or personal liberty except by a due process of law. Due process of law. But in our constitution it is written procedure established by law. Established by law. Now what does the difference mean? See, no person shall be deprived of his life. You cannot deny someone of his life except by, in our constitution it is written procedure established by law, but in other countries it is written through a due process of law. Due means proper. Due means proper procedure established by law. Whereas in our it is written procedure. Now we don't get into whether it is proper, not proper. It is understood and it is implied that a proper procedure will only be followed. But in other abroad constitution it is written proper procedure established by law. We have written procedure established by law. Meaning for us also interpretation was that obviously our procedures are proper only. Okay. The expression procedure established by law means what? That the procedure laid down by the statute, there must be a law justifying an intervention, and it must be fair, reasonable and not arbitrary, fanciful or oppressive. So the procedure should be fair, just, reasonable and proper. It should not be arbitrary. Arbitrary means random, fanciful, any random procedure, or oppressive, something that is causing harassment. So this should not be the case. Now coming to some of the rights, I told you Article 21 covers almost everything, like right to go abroad, right to privacy, right to legal aid, right against custodial violence, right to live with human dignity, right to a healthy environment, right to a fair trial. The right of a couple to adopt a child is a constitutional right under Article 21 as given here. So even a right to adopt a child is there. Now a very, very important right which I want you to take a note, okay, is Article 21A. Article 21A talks about the right to education. It talks about right to education. It was introduced in 2002, where it says that the state shall provide free and compulsory education of the age from 6 to 14 years in such a manner by law may determine. So if you go to see, it is the duty of every single person to ensure that his child is educated, and up to 6 to 14 years education is free. Obviously if you want to put them in public schools etc is different, but in certain schools 6 to 15 year or 14 years is completely free and compulsory education to all the children. Okay. Then in Environment versus Consumers Protection Foundation versus Delhi, the court held that in order to ensure compliance with Article 21, it is imperative, necessary that schools have proper qualified teachers and infrastructure. Now, in order to give them education, we also require teachers and give them the proper infrastructure. In the state of Tamil Nadu versus Shyam Sundar, it was held that the right of a child should not be restricted only to freedom of free and compulsory education, but should extend to quality education without any discrimination. So in the Tamil Nadu case, it was held that he should not only get free and compulsory, but also in that there should not be any discrimination in those schools. Then the next one, in Fahima Shireen versus the state of Kerala, upheld the right to internet access as a fundamental right. Now this was of 2019. Now internet has become so important that it is necessary this also comes under the fundamental rights, that in order to get yourself educated, internet also should be given. The court held that the right to have access becomes a part of the education as well as a right to privacy under Article 21. So you can mark it as important. In Fahima Shireen versus the state of Kerala, right to internet access is now a fundamental right. Now I told you the 51A, we did part 3, the most important articles. Now we are seeing the fundamental duties. With right comes duties. Now what is the duty of every citizen? So that is given under the fundamental duties. Now this was asked in the past exam question in your June 22 exam only. So these are all your questions of June 2022. Okay. Which is write a short note on the fundamental rights as enumerated in the Constitution of India. Can it be enforced through writs? Give reasons. Can the fundamental rights be enforced through writs? So first is fundamental duties can't be enforced through writs. It was Surya Narayan versus Union of India. Okay, Supreme Court in the AIM student case has reiterated, that is stated again, reaffirmed that though the fundamental duties are not enforceable by the courts, but they provide a valuable guide and aid to interpretation of the Constitution and its legal issues. So can the fundamental duties be enforced by writs? Answer is no. It is just your duty, but it's not that we'll take you in court if you don't do these things. Okay. Now this fundamental duties was inserted by the 42nd Constitutional Amendment. Now we'll go through some of them. You can mark it as important, very, very simple. First is to abide by the national flag, to cherish the ideas of which were there at the time of freedom struggle, to protect the sovereignty, unity and integrity of India, to defend the country when it is needed, to promote harmony and brotherhood among all the citizens, to value the rich heritage of our culture, to protect the natural environment, forests, lakes, wildlife, to develop a scientific temper, that means to become more scientific and not believe in superstitions, to safeguard the public property, to strive towards excellence in all spheres, and to provide opportunities for education to one's child. So these are the fundamental duties. Now I'm coming to the next most important part, that is the writs. So I'm going in the order of importance and the order of repetitiveness asked in the exam. That is your writs. Now let's understand what are the writs and the different kinds of writs. First, I need you to tell me under which article is the fundamental rights given. All the fundamental rights are given under which part of the Constitution? So again, so part 3 of the Constitution, part 3 of Constitution talks about fundamental rights, right? So you have certain rights we saw, right to freedom of speech and expression, right to life, all those have been given, right to equality have been given. Now let's say this is a person and he has fundamental rights. There is another person who comes in, okay, another person who comes in who is a bad human being, okay, he's a bad human being, so let me just make him, okay, he violates the fundamental rights, of this person, okay. This person is an angel. Now he'll be really sad that his fundamental rights have been violated. So his fundamental rights are violated. So what can be done? So he can go up to the courts. And enforce these fundamental rights and say that, see, my fundamental rights are violated. Please solve my case. So moment you go to the case, whenever your fundamental rights are violated, the application that you file in court. So the application filed in court, okay, when fundamental rights under part 3 which are violated, the application which you file is called as writs, Now why a separate name? Because moment a writs is being filed, I will immediately know that part 3 of the Constitution has been violated, the fundamental rights of the person has been violated. Okay, clear till here? So whenever the fundamental rights are violated, whenever the fundamental rights have been infringed, violated or aspersed, okay, then the aggrieved party has to go to the court and enforce and get remedy from the court. So he will go to the court. He can go to 2 courts, that is the High Court or the Supreme Court. High Court you will go under Article 226 and Supreme Court you will go under Article 32. Concept clear? To enforce your fundamental rights. Now they have said that, listen, when the person is crying that his fundamental rights are violated, I'll tell him, don't cry. Don't cry. Wherever there is a right and it is violated, law has also provided a remedy. For every right there is a remedy given under UB Jis Remedium. Okay. Now if the rights are given without remedy, then they are of no use. So the remedy can be given in High Court under 226 and Supreme Court under 32. Now there are the 5 different kinds of writs. There are more kinds of writs, but their naming has been given of 5. Habeas corpus, mandamus, prohibition, certiorari, quo warranto. Short exam question. Okay, short exam question. You should know this along with the language. Let me explain you what is habeas corpus. Habeas corpus means bring the body. Means to bring the body. To have the body. So I'll tell you what does habeas corpus mean. If any person has been illegally detained, he will file a writ of habeas corpus in the court. Court will tell, bring the person who has been detained illegally, who has been imprisoned illegally, call him, have the body, bring him. And the court will check the legality of his detention. If it is found that the detention, imprisonment, custody is illegal, we will order the release of that person. The court will order to release the person if he has been detained illegally. The object of this writ is not to punish the person who has been illegally detaining another. Object is not to punish someone who is you have illegally detained. Object is not that. Object is to secure the release of the person who has been detained illegally. So let me read. So that means if sometimes there is a bomb blast or there is some person we catch and we put him in jail. Now he is innocent, he will file a case in court. So it means to bring the person who has been detained to see the legality of his detention. If he is wrongfully confined or illegally detained, the court will order the release of such person. The writ of habeas corpus is a remedy available to a person who has been confined, that is closed, imprisoned without a legal justification. The object of the writ is not to punish the person who has illegally detained another, but to secure the release of a person who has been so illegally detained. So the object is to release such person who is wrongly detained. Okay. Now, writ of mandamus. Writ of mandamus. Mandamus means to command. So a higher authority commands lower authority, or command means orders lower authority to do the public duty. Firstly, there should be a lower authority. That lower authority should have some public duty to perform. If they are not performing the public duty, the court will tell that what are you doing? Do your duty properly. Now this order, this command can only be given to a lower authority. Obviously you will give command to someone who is lower than you when that lower authority is not doing their public duty. For example, the municipal corporation, the police, any authority which you feel is not doing the duty, the court will say, what are you doing? But you are a public servant, do the duty properly. This order, command cannot be given to a private body, because private body is not answerable, responsible to the public. So only to government departments it will be given. So writ of mandamus is a command, order issued by any person to any person, is issued to any person having a public duty to perform, and order will be do your duty properly. This writ is used when the inferior tribunal or the inferior authority has declined, has neglected to exercise their powers, while resorting to mandamus can be issued against any public authority. Okay. Now the duty must be of a public nature and should not be of a private nature. It is a discretionary optional remedy of the courts. High Court might decide not to order the lower authority. They say, no, the lower authority is doing proper duty, I don't want to order. Now comes prohibition and certiorari. Prohibition means and certiorari. Now what does it mean? Prohibit means to prevent. Prohibit means to prevent. And certiorari means to squash. To squash or set aside. Set aside. Both of them are used in similar cases but at different stages. Let's understand. If a lower court, let's say if you're junior, you are a senior today, if someone in CSEET is not studying properly, will you not order them? Listen, you will fail. Listen, study properly. So when a higher authority tells the lower authority that listen, you have taken a wrong case, you will pass a wrong judgment, you will do something wrong. So order will be given to prevent the lower court, from passing wrong judgment. So the lower court will say, how you know I am going to pass a wrong judgment? I have not yet passed. Order not yet passed. Judgment not yet passed. How the senior can say that I am going to do something wrong? So the court will say, the higher court will say that listen, you've taken up a matter which is not in your jurisdiction, which is not in your powers. You have exceeded your powers. You have exceeded your jurisdiction. So we are preventing you from aspersing the jurisdiction which is not legally vested in you. From aspersing. Aspersing means what? Exceeding your powers which you don't have. For example, a small causes court. A small causes court, okay, can take up matters, let's say up to 1 lakh. Up to 1 lakh only. But still, small causes court is taking a matter of 1 CR. So the High Court will pass an order to the small causes that listen, your limit is only till 1 CR, 1 lakh. Why are you taking 1 CR matter? So don't pass the order. This is called as prohibition. So when the lower court or the tribunal has exceeded its powers or is exceeding its powers, it will be ordered not to. Now coming to certiorari. Now what if the lower court has already passed the judgment? So they will squash or set aside a judgment already passed. Judgment already passed. So if the superior court came to know that the inferior court has already passed a wrong judgment, then we will call for the records. We'll say, bring here what you did wrong. Then we will see that the wrong judgment was given. Then the High Court will squash aside the judgment and pass its own judgment. Okay. So here the higher court squash the decision that with lower authority is when they have exceeded the jurisdiction, passed the judgment on which they didn't have jurisdiction, violated any principles of natural justice, or made an error apparent on face of record. They made a very obvious error. So in that case we will do. So first, if the judgment is not passed, prohibition will be ordered. If judgment is already passed, certiorari will be ordered. The next we come to is quo warranto. Quo warranto means by what authority? So let's say if there is a politician, he has favored his own son and he is giving him the job, the government job. And there is another one who is an IS officer who is ranked and worked hard, and he is saying that I would have got the job because you gave it to your son, I did not get. So my fundamental right is being violated. So when a person feels that there is a public post, so first there must be a government office, there must be some public office, public post. Let's say there is a railway office or a post there, a railway post. And what happened? The politician put his own family members in this post. So there must be a deserving candidate who will be very sad, and he will say that listen, this politician is putting all his people in this public post. I would have got the post. So then the court will call this person, this politician, and tell him by what authority are you getting this post? How did you give this job? How did you get the job? So the holder of the office, the person who is currently holding, will have to show to the court by what authority he holds the office. It is issued when the offices of public created by the statute, so all the government posts are there, and the respondent, that is this deserving candidate, is ascertaining his claim to the office. He is claiming that office. He is saying, no, I should get that office. The fundamental basis of proceeding of quo warranto is that the public has interest to see that a lawful claimant does not grab a public office. We don't want that there is some random person, who is grabbed a public office. So if there is a public post, you can ask anyone by what authority did you get this post. Then comes to the structure of the constitution. The structure of the constitution. Now you tell me, this is another important question that they ask in the exam. Is our constitution unitary or it is federal? It is unitary or it is federal? So the answer is it has features of both, and that is why it is called as quasi-federal. Quasi-federal means partly federal. So this was asked in the June 2022 exam. So in the June 2022, they have asked about the federal polity is incorporated in the Indian Constitution. Examine. So now we have to examine and explain. Okay. First, so we have to tell what are the federal features is what they had asked. The essential features of a federal system. Again, now worldwide the constitutions are differently made. Some are quasi-federal, some are federal, and some are unitary. Indian constitution is quasi-federal. It has features of both. Federal, from the word, let me explain, okay? From the word unitary, you can make that all the powers are united in hands of someone. Like there is a single person there, like single citizenship. There is a precedence rule. So those features we have. In federal features, it is more about not united, it is divided. So there is a division of power. So in our constitution, there is features of both. So let's see. First, federal features. The main features of federal is that we have a dual government. Federal essential features of federal system, dual government. So yes, we have a dual government. We have central government also and we have state government also. So the powers are divided. This federal feature is there. Then comes distribution of powers. So yes, the powers are also distributed. Okay, of which government will, central government has got certain powers, state government has got certain powers. So that is given in the Schedule 7, which it gives powers in the union list, state list, all have been distributed. Then there is a supremacy of constitution, that no person is superior. The most superior book is your constitution. So therefore this federal feature also we have. Then independence of judiciary. Independence of judiciary means what? That the judiciary, that is your courts, will be independent. The judges can pass whatever judgment they want and nobody can interfere with that. So that feature is also there of federal. Then written constitution and a rigid procedure to amend it. So this feature is also there of the federal structure in the Indian constitution, because in Article 368 it's very difficult to amend the constitution. Now we will see certain unitary features. Unitary features of the constitution. Single citizenship. So in India we have only single citizenship, whereas in Canada you can have dual citizenship. Precedence rule. Precedence rule means what? That at certain times when there is a external aggression, war, precedent rules can be declared where all the powers will be united in the hands of the president. Then comes residuary powers. So this feature is also there. Residuary feature is also there. That if any matter is not there in any of the state list, the union list, state list, in any of the list it is not there, then the residuary matter will come under the head of the center. That is also given. The next is judiciary. That the Supreme Court's decision will be binding on all the courts. So this is also like someone like a supreme, the unitary, where one decision of the Supreme Court is binding on all, as given in your Article 141. So thus we see that our constitution is nearly purely federal nor purely unitary. It has features of both. So we'll just take a 5-minute break. Okay. So we'll take a 5-minute break and we'll return back. Okay. So 5 minutes. You can go ahead and inform your friends that there's a lecture going on to join it. Okay. Just give me 2 minutes. 5 minutes. Okay. Hi guys, am I audible to you all now? Am I audible now? I just need you all to put in the chat box. Okay, so do share it with your friends, inform your friends also. There are lectures going on. I want to help all of you all. You should also be, if you're liking it, definitely please inform your friends to join the WhatsApp groups mentioned in the description, also the Telegram groups. Okay, now I just need a small check whether I'm audible to you all or no. Okay, so am I audible and visible? Yes or no? Okay, so let's begin with the lecture. Okay, now power of the parliament to make laws on the state list. Now what happens, understand that the constitution of India under the schedule 7, in schedule 7 there are three lists. There is the union list, then there is the state list, and then there is the concurrent list. Okay, now the matters are clearly divided, that certain matters which are given in the union list, only the union government can make the law, that is the central government. So whatever is given in the union list, only the union government can make the laws. State list, whatever is given in the state list, only the state government can make the laws. And concurrent list is whatever is given in the concurrent list, both the government can make the laws. But there are some matters, or in some cases, in some circumstances, the union government can make laws which are mentioned in the state list. So whatever is there in the state list, the union government, that is the central government, can make laws. So this power is there in certain cases, which we will see. So the question comes like this: under what circumstances can the union government, under what cases can the central or the union government make laws on matters stated in the state list? So we will see. Very first is in national interest under Article 249. In national interest given under Article 249. So if at any point of time, when 2/3 of the members of the Rajya Sabha pass a resolution that the central government should make a law in national interest, so 2/3 of Rajya Sabha, so the parliament can make a law, that is, a parliament means the central government can make a law on any matter enumerated means stated in the state list, if the council of states, that is Rajya Sabha, declares by a resolution supported by 2/3 of its members that it is necessary and expedient in national interest to make a law on certain matters, so then the central government will make the law. So Rajya Sabha members themselves are saying that make a law in national interest, so it will be made. Next is when there is a proclamation or declaration of emergency under Article 250. So during emergency, the parliament shall have the power to make the laws for whole or any part of India mentioned in the state list. Under Article 352, if the President is satisfied that there is a grave emergency exists whereby the security of India is threatened by war, external aggression or armed rebellion. So if the President of India is satisfied that there is a grave major emergency in India where the security of India is threatened by way of war, external aggression or armed rebellion, then he may by proclamation declare to that effect. It is not necessary that an actual war should be there, but just that if he feels that a war is going to be there, he can take all the powers in his hands. Next is breakdown of constitutional machinery in the state. So Article 356 and 357. Okay, if the president feels that a state is not being governed by the constitution, then it will take, and there is a breakdown of the constitutional machinery, that the constitution is not being followed only, then the center will take control over the state. So in case the governor of the state reports to the president, okay, or otherwise the president himself is satisfied that the state cannot be functioning, is not functioning as per the constitution, then the president will make a proclamation, a declaration to the effect that the state is not following the constitution, we will take over control over the state. When two or more states themselves request, when the states only go and tell the center that make a law which is applicable on both of us, then if the states are only saying make a law, then the center can make a law. Then next is another international agreements given under Article 253. So whenever the Parliament makes a international agreement, so for example Indo-Mauritius Treaty, when India has made a treaty with Mauritius or India has made a treaty with some other country, obviously when we say India means all the states. So in international state, no state can say no, I will not follow. It's a full state, country will have to follow the law when we enter into international treaty. Now we will see your article number. Now we will see article number 12. Very important past exam question. So it's a past exam question. It talks about article 12. It defines state. State shall include. So state, when we use the word state, it includes the government. It includes the state government, central government. This is for the union government, state government, all the local authorities, any other authority coming under the control of the government. Now, why is it important to understand what all is included in the definition of state? What is important? Why it is included in the definition of state? So very simple. Okay. If today I want to file a case on the state government, and I want to say that the state government has done wrong and the state government should give me compensation. So we will have to know whether that is covered under the state government or not. So we will have to understand. So if any local authority is there and it has done something wrong, from the state government's funds it will be debited and it will be given to the person. So local authorities like municipal, district boards, port trust, etc. Okay, local authorities, all of them are covered since they are under the control of the government. In Z Telefilms versus Union of India, the Supreme Court held that the BCCI is not state under Article 12 and it is not shown to be financially, functionally, administratively dominated or controlled by the government. So is BCCI state? So answer is no. Okay, it's a private body. Next is this is very, very important to determine that whether a authority or whether a particular entity is state or no. So a litmus test has been given, a particular test has been given, that is Ajay Hassania versus Khalid Mujib. The Supreme Court has enunciated means stated the following test for determining whether an entity is an instrumentality or agency of state or not. So they have given you a particular list to determine that whether it is of state or not. So how will you come to know? If the entire share capital is held by the government, or if financial assistance of the state or expenditure of the corporation is handled by the state. Means what? I want to find whether this authority is state or no, coming under the definition of state. So if anyway this authority is being controlled by the government, funded by the government, run by the government, set up by the government, then it will be said that this authority is coming under the definition of state. And if this authority does something wrong, compensation will be given by state government. Next is whether the corporation enjoys a monopoly status as conferred and protected by the state. So if monopoly status is given and protected by the state, then again it is a definition of state. Whether there is a existence of a deep and pervasive state control. That means pervasive means deep. Control is there of the state government. Then we can say that it is the state only. The functions of the corporation are of public importance. For example, BEST, the electrical department. Okay, railways. So it will be covered under state. If the department is transferred to a corporation, okay, if the department of government is transferred to the corporation, then again it would be a strong factor to support an inference relation that yes, this department or corporation is an instrumentality of the state. It is a agency of the government. Then comes the directive principles of state policy. Directive principles of state policy are given in your part 4 of the Constitution. It says that the states shall direct its policy towards achieving these principles. That the state should direct its policies to achieve these principles. Now these are just most ideal principles and we cannot force the state to definitely give. Okay, so if these principles are not given, it is not actionable or in courts. So these are not actionable in courts. Means if the state government cannot give you these things, you cannot go in court and say that no, give me. Okay, they will try to give you. So the two types of fundamental rights, one which can be enforced in law, that is part 3 of the Constitution. If the part 3 is not given, you are allowed to go in court and file writs. But if those given under part 4, that is directive principles, you cannot go in court. The directive principles of state policy contained in part 4 contain and set out the aims and objectives to be taken up by the states while running the country. These lay down the guiding principles which the state must keep in mind while framing the law. So these are certain principles which the state must keep in mind while making the law. The framers of a constitution have chosen a middle path between ideal and practicable. Okay, so they have said that this is very much possible. You should try to make your policies. These are good guides but cannot be enforced. Very, very important line. These are good principles but you cannot force the government to give you. Then what is the object? The object is that such ideals, such principles must be kept in mind while making the law. So while making the law, we have to keep these things in mind. So what are few examples of this? Some of the directive principles are as follows. Okay, to secure social order for promotion and welfare of the people, that is welfare of the people. Ensuring that everyone has an adequate means of livelihood. Organize village panchayats, give humane conditions of work. Okay, good standard of living should be given to all. A uniform, we have in India, we have a uniform criminal code. But do we have a uniform civil code? Do we have a uniform civil code? Can you tell me in which state is the uniform civil code applied? In which state is the uniform civil code applied? Can you all tell me? Okay, in which state is the uniform civil code applied? Uniform civil code is in which state? Okay, so very good. The answer is only Goa is the only place. Okay, Goa is the only state in entire India which has applied the uniform civil code. Okay, Next is the state shall endeavor to protect and improve the environment. Okay. And in international matters, the state must endeavor to protect, promote peace and security and maintain just and honorable relations with the other nations. So these are some of the directive principles that we should try to maintain friendly relations with others. Next, if we see your another very important article is your article number 20. So protection in respect of conviction of offences. Article number 20. Now article 20 talks about guarantees to all persons, whether citizens or not, whether citizens of India or not, the protection against ex post facto law. Protection against ex post facto law. Post facto means what? Later these laws have changed. So let's see what does article 20 subrule 1 talk about. So I will read. I'll see whether you understand or no, and I just want you all to tell me whether you understood or no. Then I will explain. First, no person shall be convicted of any offence except for violation of a law which at the time of commission of the act charged in an offence, nor be subjected to a greater penalty that which might have been inflicted under the law at the time of commission of the offence. Did you understand? Yes or no? So it says very simple. No person shall be convicted of an offence if it was not an offence when it was done. No person shall be convicted of an offence unless it was an offence when it was done. For example, in 2012, okay, I'm just saying that in 2012 there was an act which was legal. In 2013 the same act became illegal. The act became illegal. Tell me one thing, if there is this person who was doing this act here, can I retrospectively apply in backdated apply the law and tell that this person will get jail? But what he will say that, listen, when I did the act in 2012. In 2012 the act was legal. So I cannot be punished as per article 21 because at the commission of the act, when I did the act, it was not illegal. So let's read. So no person shall be punished, convicted for an offence except if it was a violation of the law at the time of commission of the act. So when I committed the act, if it was a violation, at that time if it was a violation, only then I can be punished. This is the first part. Second part says, nor, after nor it starts the second part, nor shall I be convicted for an offence which is greater. So let's take another example. Same act, act was done in 2012. Okay, act was done in 2012. That time when you did the act was illegal. It was illegal, but the punishment for this act, the punishment was 3 years. Now he did the act here. Later in 2013, the punishment was increased. The punishment increased. Punishment became 5 years. Tell me one thing, can I punish this person for more than 3 years? He did it in 2012. Can he be punished for more than 3 years? Answer is no, because no person shall be punished, convicted with a penalty greater than what was there when the act was done. Okay, nor shall he be subjected to a penalty greater than which might have been inflicted in force at the time of commission of the offense. Clear? Next, ex post facto laws are laws which are punished when the law was lawful when it was done. If a particular act was not an offense at the time when the person did that, then he cannot be convicted under law with retrospective effect declares that as an offense. So if I did an act which was not punishable at the time of doing, I can never be punished for that act. Okay, nor can I be punished for a greater penalty than what was the penalty when the act was done. So this was your Article 21. Now we are doing Article 20 Subrule 2. Now we are doing Subarticle 2, which says no person shall be prosecuted and punished for an offense more than once. So no person shall be punished, shall be prosecuted, that is put in jail and punished for the same offense more than once. Obviously, if you have done an offense, you will get punished only once. No person shall be punished twice for the same act. So this is called as protection against double jeopardy. Protection against double punishment, double jeopardy. The next is protection against self-incrimination. Protection against self-incrimination. It says incrimination means self-destruction. So no person can be forced to give a statement against himself. Even if I am forced to give, it will not be valid before the court. So sometimes a police officer punches the person, hits him, and then he agrees that he says, yes, I have done the crime. So that statement is a self-incriminating statement. That statement is a self-punishing statement. So this statement will be invalid in court because before police officers, everyone gets scared and makes a self-incriminating statement. So it is not valid. But a statement before the magistrate or the judge is valid because the judge will not hit you, right? So a statement before police officer is invalid, but a statement before judge is valid. According to Article 20 Subrule 3, no person accused of any offence shall be compelled. Compelled means forced to be a witness against himself. Matlab means witness means I am myself becoming a witness that yes, I have done the crime. Okay, in other words, an accused cannot be compelled, that is forced, to state anything which goes against him. But it is to be noted that a person is given protection only when all the three conditions are fulfilled. First, he should be an accused. There must be a compulsory or force to be a witness, and such compulsion should be giving a evidence against himself. It covers those who apprehend that their answers could expose them to criminal charges in ongoing investigation. So it covers those who feel that their answers will make them more in trouble, so they have a right to remain silent. Next, if we see protection against arrest. So we did article, please note it down, these are all important exam questions, and constitution is the most weighted chapter. Confirm questions come from here. Okay, now we see article 21, 2, 3. This is about double jeopardy. Double jeopardy means double punishment. Nobody can be punished twice for the same offense. 3. Protection against self-incrimination. Okay, against self-incrimination. Self-incrimination means what? Self-incrimination means self-destruction. Nobody can force me to give a statement which will be used against me only. And lastly, this is protection against ex post facto laws. That is, laws which have come later on, I cannot be forced to or I cannot be punished for an act which was not punishable when it was done. Okay. Then comes Article 22. Protection against arrest and detention. So very, very simple, under ordinary law and under preventive detention. Now first is, if a person has been arrested, he has 3 rights. He has how many rights? 3 rights. He should be informed why you are arrested. Second, he has a right to be defended or protected from a legal practitioner. Third, he has to be brought before the magistrate within a period of 24 hours. Okay, 3 facts. Next is preventive detention. Preventive detention means what? Person has not done anything, but we feel that he will do something. So in order to prevent him from doing an act, we will detain him, imprison him, or confine him, or put him behind bars. I'll explain. If we feel that this person is a terrorist, he will do a bomb blast, will we let him do to catch him? No, we will hold him, we will do investigation. So here, think from both sides. From the government side, we'll obviously catch him in public safety. Think from the person's point of view, the accused. What if he's not a terrorist? So his rights are also getting violated. He's an innocent person, for example. So law has given protecting both the sides. So here it means preventive detention means detention of a person without trial. Object of preventive detention is not to punish a person for having done something, but to prevent him from doing something. This is done. No offense is proved yet. Yet a person can be detained under this provision. Okay. Now safeguards. Now to protect this person that who is being detained, few points have been given. Safeguards against preventive detention. First, a person cannot be detained for longer than 3 months unless a proper advisory board has been constituted and they feel that such detention is necessary. Means maximum period is 3 months unless some advisory board is saying no, we want more than 3 months. Sometimes people are spy. Okay, so that time we have to do. Next is authority concerning the detention shall communicate to him the grounds for his detention and give him an opportunity of legal representation. So within 3 months we have to release him, or an advisory board will say no, extend the time period. He will be told why he is being detained, and also he will be given a legal practitioner to defend himself. Then comes with the next point, that is your delegated legislation. That is your delegated legislation. Okay. Market is important again. Okay. This is also important in past exam question. Now, what do you mean by the term delegated legislation? Legislate means to make the law. Okay, so let's see. To delegated legislation. Delegate means to transfer powers to another. Transfer the powers to another. And legislation means to make laws. So collectively put, delegated legislation means to transfer the powers to someone else to make the laws. Normally, it is a duty of the parliament to make the laws. So the parliament delegates these powers. They delegate the powers to make these laws to another authority, because parliament doesn't have time to make all the small little laws and details. So when this authority, so this will be called as delegated, this will be called as delegated authority. to whom the powers have been delegated. When the delegated authority makes the law, it is called delegated legislation. It is called delegated legislation. Concept clear? That the parliament has transferred the power. So let me explain, okay? The entire GST Act has been made by the parliament. So your CGST Act 2017 has been made by the parliament. Yes or no? Through the bill, they have passed this law. But the day-to-day powers are not made by parliament. Every day there is a form filing change, there is some procedural change, there is a rate change, there is an exemption. Parliament doesn't pass that. Who passes it? So the power to make the laws has been delegated to GST Council, has been given to the GST Council. And if you notice, the GST Council nowadays makes the laws. So when the GST Council is the delegated authority, when they make a law, it is called as delegated legislation. So let's take examples of that, why it is needed. Why the government and the parliament needs to delegate the powers. Need for delegated legislation. First, there is a lot of work, there is a lot of pressure on the parliament, so they have to delegate. Second, the subjects, tax is a very technical subject, like that information technology will be a very technical subject. Every subject requires expertise, so better to give it to that expert or authority to make the laws. To meet unforeseen emergency situation. So if there is some emergency situation, okay, so they will make. And next is flexibility. Okay, because see, parliament cannot sit every time. So if there's some emergency situation, parliament will take a lot of time, but the authorities can make it immediately. And flexibility. So it is more easy to make changes in the law if it is given to this authority. Next, if we see classification kinds of subordinate delegation. First is there are 5 kinds of subordinated delegation. 5 kinds, very simple. First is executive legislation. When the executive makes the law, it is called as executive legislation. For example, who is the executive of the security market? Who regulates the security markets? Please put in the chat box. Who executes the day-to-day functions of the securities market? Do you all know? So very good. It is the stock exchange, the SEBI. When SEBI has the executive powers of arrest, etc., when they make the laws, it is called as executive legislation. So when certain powers have been given to the executive also, those who execute the laws like the police, the SEBI, the RBI, when they make the law, it's called as executive legislation. Judicial legislation. Now we know the courts also pass some laws and make laws. When courts make the law, it is called as judicial legislation. Municipal legislation. When the municipal authorities makes, we also know that there is some municipal laws, bylaws. When they make, it is called as municipal legislation. Now very simple, from the logic, from legislation means a law making power given to municipality. Next is autonomous legislation. Now what is this? Certain authorities get autonomous powers. Autonomous means what? They are the only ones who are running it. Superior. Autonomy means one. For example, universities have autonomous powers. In India, in India you can have for schooling, you have the state board, you have the central board, CBC, ICSE colleges, ICSE schools are there, CBSE schools are there. There are certain universities. When these universities make the law, they are autonomous, they operate on their own, decide by themselves. It is called as autonomous legislation. In your college, Today they will make a attendance compulsory. You have to follow it. So autonomous legislation. Parliament has not made the law. Then colonial legislation. Now colonial is what? Very simple. When colonies, earlier there used to be colonies and they used to make their own laws. The country which is not independent and under the control of some other state have no supreme power to make laws. Such countries are of various classes such as colonies, domains, protected territories. The law made by them are subject to the supreme legislation of the state whose control they are. This is a subordinate legislation. Britain has many colonies and domains. Very, very simple. We all know. Today we have kings, queens. Yes or no? Do you all have kings and queens? Do you all have kings and queens today? Yes, obviously. In United Kingdom, in UK, there is a kingship going on. So everyone else, these are all these provinces and domains and colonies. They make their own laws. That is called as colonial legislation. But they will all be subject to the state, what the head has said, the king has said. Then comes your article number 13. Your article number 13. Laws inconsistent with the fundamental rights. Very, very simple. Article 13.1 talks about existing laws and Article 13.2 talks about future laws. So let's talk about Article 13. So 13.1 talks about ex post facto laws, that is your pre-constitutional laws, and this is called as post-constitutional laws. So let's see. So Article 13.1 talks about that is before the constitution, pre-constitutional laws, and Article 13.2 talks about post, after the constitution was made, post-constitutional laws. Now let's say this is the timeline. Here the constitution was passed. So all the laws before the constitution are called as pre-constitutional laws. All the laws before the constitution, so before constitution, are called as pre-constitutional laws. And after the constitution is called as post-constitutional laws. Now very simple. Now first 3.1 talks about pre-constitutional laws. That if any law was there which is inconsistent with the constitutional, which is inconsistent against the constitution, so what will happen? If there is a pre-constitutional law, a law passed before the constitution, moment the constitution came, it came out that the constitution was, so will the law prevail versus constitution? Which one will win? Obviously the Constitution of India will win. So pre-constitutional law, any law which is against constitution, so if it is against constitution, that part or portion will be invalid and the constitution will prevail. Okay, so any part, if it is against constitution, that much part, to the extent of inconsistency, how much ever is inconsistent, that will be invalid, inoperative. Now after the constitution is made, very, very simple, direct direction has been given. No law shall be made, no law shall be made which is against the constitution. Simple. Which is against the constitution. So no law shall be made which is against the constitution. Let's read and quickly go. Laws already existing when the constitution was made. So it says that pre-constitutional laws shall be void to the extent they are inconsistent with the fundamental rights. So any law, constitutional law, if it is inconsistent, that is against constitution, that is fundamental rights given in the constitution, then that much part will become void. Okay. Next is future laws. Obviously simple, that all laws made after the constitution, okay, state government shall not make any law which is against the constitution, that is against the part 3 of the constitution, that is against the fundamental rights. Now article 13, few doctrines came up from article 13, that is your doctrine of eclipse, doctrine of severability. Okay, we will see. Now doctrine of severability, let's see. So this is all for article 13 only. First, severe means to cut or separate. Severe means to cut or separate. So let's say there is a law, pre-constitutional law. Okay, there is a pre-constitutional law. This pre-constitutional law has a valid part, valid portion, as well as it has a invalid portion. Invalid, when I say, it is against the constitution. Invalid portion. Now tell me, what will happen when it is against the constitution? They say very simple, whatever is the invalid part, cut that out, make it invalid and void, make this part void. This is the doctrine of severability, that is separate the invalid part from the valid part. So for this purpose, it means to separate the valid portion from the invalid portion. So we separated it, and if we find that the entire act is invalid, or if we find that the invalid part is so much that the valid portion cannot survive alone, so then the full act will be repealed. Okay, when a particular part or a section is found to be inconsistent, that is against the constitution, question came up that the whole act should be removed or only that part. So they said that only remove that part. But if the valid portion which is left out is not able to stand alone, if the valid portion is very little and because of that the object of the act and the purpose of the act cannot be fulfilled, then the full act will be repealed. So first we will try only to separate them and see whether the valid portion can be left alone and whether it can be allowed. So if another act is there is another act where the full act is invalid, then the entire act will get invalid, will be void. If there is another act, okay, this is the act. Now in that there is only this much is the valid portion. Now this entire part is invalid and only this much part is valid. So then they say that with this small little teeny weeny thing, the entire act cannot function. So then the full act will be repealed. Clear till here? So very simple, that's what they are saying. Okay, so how do they word it? It is not the entire law that is void, but only the law becomes invalid only to the extent which is inconsistent with the fundamental rights. So only to the extent means only how much ever. So this means how much ever is invalid, remove that. So only that part which is declared invalid and inconsistent will be, and the rest law will be valid. Okay. However, if separation is not possible, okay, then the entire law will be cancelled and repealed. Now in A.K. Gopalan versus State of Madras, it was held that where an act was partially invalid and if the valid portion was separable and the valid portion could be maintained, then it would be possible that we can leave out the valid portion only and the valid portion will remain valid. Now coming to doctrine of eclipse. Now this is another theory called as doctrine of eclipse. Mark it as important. What does it say? It says that if a law, let's say there was a which was valid. Okay, so there was a valid law. Then the constitution came. Constitution made it invalid. So made it invalid. So there was a valid law. Because of the constitution, it made the law invalid. So there was a law. Constitution came, was passed, and it made the law invalid. So this law will become inoperative. Okay, and it will become dormant. Dormant means inoperative. However, if the constitution removes the restrictions, and brings amendment in the constitution, then this law, which was inoperative and because of which restriction it was inoperative, that restriction has been removed, this law will be automatically active. So why do they say that doctrine of eclipse? So as long as the restriction, the constitutional fundamental rights restrictions are there, this law will be eclipsed. So this restriction is eclipsing, that is covering the law. If the restriction is removed, if the eclipse is gone, this act will be valid again. Okay, so there was a law, it was properly functioning, then the constitution came and it eclipsed this law. So this law became invalid, inoperative, and will be non-functional. But when the constitution restriction was removed, this law will become active again. Clear? So let's read it how they have worded. And I'll give you an example also for this. There's a very nice case for this. That is your Bikaji Narayan versus State of Madhya Pradesh. That though a existing law inconsistent with the fundamental law, so there must be a law which is inconsistent with the fundamental rights, so the fundamental rights will become valid and this law will become inoperative. This law will become inoperative from the date of the commencement of the constitution. Yet it is not dead altogether. This law has not become dead. It can always become active when the eclipse is removed. Okay, so a law made before the commencement of the constitution, remains eclipsed or dormant or inactive to the extent the shadow of the fundamental rights are there. But if the eclipse or the shadow is removed, the law will become effective again and the prohibition brought by the fundamental rights is removed by the amendment constitution. So this was the example, that is earlier the Motor Vehicles Act was there, where it stated that the state will have monopoly. So here it said that the motor vehicles, the state will have monopoly. Clear? This was the pre-constitutional law. Constitution came, Article 19(1)(g) said every citizen will have a right to do any business and profession. So this became dormant. This became dormant, inactive, and it became void. Okay, and it became inactive. Then government said that listen, we want still state monopoly. So this article was there. They brought in an amendment. They brought in a constitutional amendment and they removed the restriction that the state can have monopoly and they can restrict others. So moment that amendment came, this act will become automatically valid. Clear? That was the law. Then comes, can you waive off your fundamental rights? Waiver means to give up. Fundamental rights cannot be waived off. So your right to life is there. It's a fundamental right. You can't give up your right to life, that no, it's okay, you can kill me, I don't want to live. Okay? So you can't give up your right to your fundamental rights. It was held in Bashir Nath versus CIT, that is not open for a citizens to give up their fundamental rights. Now we come to the ordinance making power. Ordinance means a temporary law. So ordinance means a temporary law. Okay, this can be passed by the President of India under Article 123, or it can be passed by the Governor under Article 213. Okay, a temporary law. So when there is an emergency and the Parliament is not in session, like we can't go to the Parliament, so that time the President and Governor can pass a temporary law, okay, and that will become valid. This is called as an ordinance. So the important points for ordinance is where the President or the Governor, okay, in the respective articles feel that a law is immediately needed and the Parliament cannot legislate because it is not in session, it will take time and it's currently unable to do so. So they require a law to be having a temporary effect. So it will do. Now when I say temporary means there must be some validity time period. So this ordinance that it is made will be laid before the Parliament. It will be put up before the Parliament, and when the Parliament reassembles, shall automatically cease to have effect after the expiration of 6 weeks from the date of reassembly unless disapproved earlier. Now what does this point mean? The validity of an ordinance will be 6 weeks from the time the Parliament is reassembled. For example, there is a Parliament session here. So they will ask, do you want to make this valid? Till the Parliament reassembles, till 6 weeks, it will be valid. Unless the Parliament is on this day, before 6 weeks only, they have made it invalid. So the validity will be cut short. But the maximum validity that is there is when the Parliament is in session. Till the next 6 weeks, it will be valid. If the Parliament wants, they can make this invalid much before. Same it is for the Governor. The Governor will make it for the state and the President will make it for the country. The same points are there for both. Now we'll just take a short break and then we will come back and complete the remaining part of the chapter also. Clear till here? So is this clear till now? So we'll take a short break. Not a short break. Give me. Okay, so by 10:15 we will return. Okay, so by in that I will take and I will a lunch break. Dinner break, and he will complete it. 10:15 we return and we complete the chapter. Clear? So that's it. So do inform your friends, join the Telegram group, join the WhatsApp groups, inform the entire world that lectures are going on. Thank you. I'll see you all in the next time. Okay, so now we'll be continuing with the balance part of the chapter, and we will complete this entire chapter and then only we will move forward. Okay, so this is among the last part of the chapters. Okay, that's it. So I'm completing the full chapter. So it's a chapter marathon. So wait, if you're watching this entire video till the end, your entire one chapter will be done. Okay, so we will be starting. So just a confirmation, am I audible and visible? I need you all to put in the chat box and we will start the lecture. Okay. गौरव, तुम हो उधर? क्या हम लोग चालू कर सकते हैं? Can we start? Okay, great, Jyoti. What about others? Could you all wait till the end of the lecture? Okay, thank you. So now we will continue with the chapter and we will complete the entire chapter in one go. Thank you so much, Soni. Okay, so let's start. Great. Sondar, Karthi, great. Thank you. Okay, so I will be starting. So be with me till the very end and your one chapter is done from exam point of view, past exam questions, everything. Okay, probably what will come in your exam, everything is going to be covered. So let's start with the topic. The next rule that we are doing is your doctrine of pith and substance. Now when I say the pith and substance means what is the main pith and substance, the main essential character of a law. Now, sometimes we have to understand what is the essential character of a law. Why? Because let's get into this, that we know that as per Schedule 7, the powers of the government are distributed in three lists. Powers of the government are distributed in three lists. First is called as a union list. That's your list 1. Then comes the state list, that is your list 2, and then comes your concurrent list, which is your list 3. Right? Concurrent list is your list 3. Now the question comes up that matters which are given in list 1, only the central government can make laws. Matters mentioned in list 2, only the state government can make laws, and matters stated in list 3, both the governments can make laws. Now it's very simple. If a matter is stated here, can you tell me which government will make the law? Quickly in the chat box. If the matter is stated here in this segment, which government will make the law? Very good, the union government. If certain matters are stated here, which government will make the law? Quickly put in the chat box. If the matter is stated here, which government will make the law? Very good, the state government. But it is possible that there are some matters which are on the line. Some matters which are very much on both the sides. So the doctrine of pith and substance is to cover these matters which are on the line. We have to see that whether the main law is being passed is really for the matter which is given in state government. So let me explain with the help of an example, and a very beautiful example has been given to explain this. It is given in the case of G. Chawla versus state of Rajasthan. G. Chawla versus state of Rajasthan. So let me explain what it was. Now there was in the list, it was mentioned that the union government can make a law make a law with respect to information and broadcasting. Broadcasting laws can be made by union government. Okay. And in the state law, it was written that public health and sanitation was given in the state list. Okay, so this was the powers given. Now the state government passed a law on loudspeakers, that loudspeakers should not be used after 10 p.m. Now what happened? This got challenged before the court. That the union government said, listen, this is a matter of information and broadcasting. These loudspeakers are used to broadcast information, broadcast the sound. So it is our matter. It is in our powers. We will make the law on loudspeakers. Whereas the state government said, listen, it is not for broadcasting. We made it for public health. Loudspeakers playing after 10 o'clock. So it was like an overlapping matter. So in such case, if we want to see whether the state government did right or wrong, was the state government correct in making the law? I want you to put yes or no. Was the state government correct? Then put correct. If the state government you think was wrong, put incorrect. So the state government, the Supreme Court found that they went into the pith and substance, the essential character of the law, and they found that the main law why state government passed was for public health, and therefore they said that this state government has the power. Clear till here? So the state government was correct. So here it says that doctrine is mainly used when a law is challenged. A law on loudspeaker was challenged on the basis that the government has encroached, that the state government in this case has encroached into the powers of the central government, has encroached, transgressed, trespassed upon the powers of another government. Then the rule of pith and substance is applied, where in reality it is falling in an item on which the legislature has enacted the law is competent to legislate. Then such law shall not become invalid merely because it incidentally touches upon matter outside the competence of its jurisdiction. Means, if a law falls within on which the legislature has enacted the law is competent to legislate. So I have made a law on a matter which I am competent, fit to make. This law will not become invalid merely because it has incidentally touched upon a matter of some other state government. It was observed by Grover that it is possible that a matter which is in one list touches upon also matter of another list. In such cases, strict verbal interpretation would result in a large number of statutes becoming invalid. If we start saying no, incidental, if it is touching, that will become invalid. So then many laws will become invalid. Therefore, where such overlapping occurs, the question must be asked, what is the pith and substance of the law? If the true nature and character is being found, then it will be allowed. This was the example which I had given you of G. Chawla versus State of Rajasthan. Then comes the doctrine of colorable legislation. Now let's understand this next doctrine. Very, very interesting and important too. Colorable means gadbad, some kind of problem, some kind of issue is there in the legislation that has been passed. Okay, now what do you mean by colorable legislation? What do you mean by colorable legislation? So a colorable legislation is, it is a law, it is a law, it is a, actually it is a invalid law, it is a invalid, illegal law, illegal act, which is being passed under the color of being valid, under the color of being valid. So it's actually an invalid law or act, and we are trying to pass it under the color of being valid. So again, it is a, just to give you a graphical image, it is a wolf in a sheep's clothing, okay. So what is happening is, we feel that it is a sheep, we feel that it is a valid law, it is a proper law, but in reality it is trying to do something illegal. Another example of this is, the state government has made a law which looks valid, which looks that it is for the people, it looks as if it is very good, but in reality it is bad, but in reality it is illegal, in reality it is a fraud. So is colorable legislation going to be allowed? Answer is no, it is void. So colorable legislation is something which is confusing and it is coming across as valid, but in reality it is invalid. So here also a very beautiful example has been given, beautiful example has been given in Kamleshwar Singh versus State of Bihar. Here, what did they say? It was a Bihar Land Reform Act which was declared to be colorable legislation and it was declared to be void. So let me explain the case. What did they say? That the Bihar government passed a law that landlords are there and there were tenants who were there who had not paid the money, not paid rents. Okay, so what did the Bihar government say? They told the landlords, okay, so these tenants have not paid your rent. They have not paid your rent. Wait, we will collect for you. We are good. We will help you collect the money. So we will collect 100% of the rents. We will collect 100% of rent and we will give you 50% rent. So the landlord said that the law that you are making, that you will collect 100% and give me 50, is not helping me. It is in reality you are stealing my 50%. So the Bihar government, which showed that they are passing a law to benefit the landlord, but in reality they were stealing from the landlord. And it was found that this law is invalid and it was held to be colorable. So under the color of acting beneficial to the landlords, you are actually making something which is more harmful to the landlords. So it is based on the maxim that if you can't do something directly, because the law is not allowing, so don't try to do it indirectly under the color of being valid. It is a legislature having no power to legislate frames a law. So when you don't have a power to make a law on something, you disguise it. Colorable means to disguise the same as to appear within its competence. Okay, a legislature may pass a law which gives it the color of constitutionality. It gives the color or the feel of validity, while in reality it is aiming at achieving something which the legislature cannot do. Okay, so here the Bihar Land Reforms Act unpaid rents by the tenant shall vest in the state. So all the unpaid rent, the state you will take 100%, only half of them is paid back to the landlord. So they said that, so the Supreme Court found out that the power that taking the whole and returning half is nothing more or less than taking without any return, and it's a naked confiscation no matter whatever deceptive form it may be clothed or disguised in. Clear? Now moving ahead to some of the articles which you can quickly read. So if we see article number 12 is the definition of state. Article number 13 is about separation of the valid invalid part. Okay, pre and post constitutional laws. Article number 14 is about equality. Article number 15, and I don't know whether you've seen, there was a movie that was passed, article number 15, which was about discrimination on the basis of religion, caste, etc. So the state shall not discriminate on the religion, on basis of religion, sex, religion, gender, place of birth, etc. Article 15 lays out that no citizen shall be subjected to any disability, restriction or condition with regard to. So this talks about no discrimination or against the people. Now in abroad there is between whites and blacks, okay, color, non-color. So here what they said that even in India there can be discrimination on the basis of the caste, creed, religion, gender, okay, sexuality, all of that can be done. So here they say that no citizen shall be subjected to any kind of discrimination with regarding to access of any shop, public restaurant, hostel or hotels, public entertainment, or use of wells, tanks, ghats, etc. Because sometimes they say no, you are untouchable, you cannot touch this, you cannot enter in the shop, you cannot take the water. So that will not be allowed. Article 15, 3 and 4 says that the government can make special provision for women and children and for economically backward class. So when I say discrimination is not allowed, okay, but to favor the SC, ST, women, economically backward class, that is allowed. So that will not amount to discrimination because we are giving favors to them because they were little disadvantaged. So it's a reasonable classification. Then comes Article 16. Equality of employment in public, equalities in matter of employment. So men and women should get equal pay for equal work. So there will be equality of opportunity for all the citizens, and it prohibits discrimination against a citizen on the grounds of religion, race, caste. Again, okay, no discrimination should be done, especially when they want to get some office or some job. The Supreme Court in the state of Karnataka versus Uma Devi held that adherence to the rule of equality in public employment, okay, so getting in all these government jobs is a basic feature, and this is the core of the constitution. Okay. Then comes Article 17, abolition of untouchability. Is untouchability allowed in India today? Obviously not. Untouchability is abolished and its practice in any form is forbidden. Enforcement of any disability arising out of untouchability is a punishable offense in India. So if you try to enforce untouchability, you try to implement untouchability in India, you will be behind jail. You will be behind bars. Article number 18, abolition of title, sir, madam, king, all of that is disallowed. No person is allowed to take such, accept any such title such as Mahatma, because it leads to inequality, it leads to discrimination where this person will be treated very superior. Okay, then sometimes these people misuse that powers and people start worshipping them. Okay, and they can get away with any kind of crimes, and also any kind of title which makes you higher superior is disallowed. However, getting any kind of awards, Padma Bhushan, Bharat Ratna, Padma Shri is not amounting to titles, and no citizen can even accept it from any foreign state. So sometimes they want to give you any, this is not allowed. The President of India's consent is required if you want to accept any titles, and titles which they receive in your military is not covered under this title. So they give you certain badges, some stars, that is not amounting to titles, because obviously we are talking of just giving you some titles. Okay, this is not allowed. Then Article 19 we had seen, we had done. Article 20 we had done. 21, 21A, very very important. 22 we had done. Then coming to Article 23 and 24, right against exploitation. So Article 23, it talks about prohibition of human traffic, prohibition of traffic in human being and forced labor. Very very simple. What do you mean by human trafficking? What do you mean by human traffic? It means to buy and sell human beings like you buy and sell goods. So you can't, earlier they used to trade human beings, not allowed completely. Okay, sometimes you see in all these traffic signals etc, they buy children, they rent out children, all of that, or there is some smuggling of people, all of that is a crime. Next is prohibition of children to work in factories, article number 24. We also have your child prohibition act, where children below 14 years cannot be put in employment. So that is in article 24. Then religious freedom is given in article number 25 to 28, right of religious freedom. So any person wants, he can practice any religion he wants. Okay, he can manage the religious affairs the way he wants. He can pay taxes, that is any kind of donation he wants to give to promote any religion, he can do that. He can attend religious institutions, workshops, seminars, all of that is allowed. Then comes your cultural and educational rights. So again, cultural rights means to protect the minority and the culture of the minority, the language, etc. So article 29 deals with protection of language, script, culture of minorities. Right of minorities to establish their own educational institutions are given in article 30. Then comes, you've done all of this, then amendability of the fundamental rights. Now question came, can you amend the fundamental rights? I want you all to put in the chat box, can today you amend the fundamental rights? Yes or no? And for amendment, the article is article 368 in part 22, deals with the powers of the parliament to amend the constitution. Can the fundamental rights be amended? Yes or no? I just want this from you all, okay? Can we amend the fundamental rights? Yes or no? I want you all to put in the chat box. So the answer, very good. So earlier there was the Golaknath case, and there were certain cases before where they said that the constitution and the fundamental rights cannot be amended. Then they said no, fundamental rights can be amended without as much as you want. Then a landmark judgment has been passed, and this is what is valid today, and all of you all should know this, okay? Can the fundamental rights be amended? Answer is absolutely yes. But while amending the fundamental rights or the constitution, the basic structure of the constitution cannot be amended. Now what is a basic structure? The basic philosophies such as the rule of law, the sovereignty, secularism, judicial review, all those things are the basic ideas which are given in your preamble, that cannot be amended. Okay, so the parliament can amend the fundamental rights under article 368, okay, but basic features of the constitution cannot be amended. This was given in the landmark judgment of Keshwanand Bharti versus State of Kerala. It was held that no part of the constitution, including the fundamental rights, were beyond the amending power. However, the basic structure cannot be abrogated, amended, changed. Okay. Some of the features of the constitution are termed as below: supremacy. These things cannot be amended. The rule of law, separation of law, the judicial review, Article 32 to 26, secularism, federalism, okay, sovereignty, democratic republic. So mostly what is given in your, that it will be a welfare state, which is given in the preamble. Conclusion: so the basic structure of the constitution cannot be amended. Then we talk about the judiciary. The topmost apex court in India is the Supreme Court. Then we have the high courts. Okay, in India, in every state we have a high court. Then comes subordinate courts, where the matters are first tried, and from there appeal it generally goes in the high court. Separation of powers. Now, what do you mean by separation of powers? Now, there are three important organs of the government. In India, there are three important organs: the legislative, executive, and judiciary. The judiciary are none other than your courts. They interpret the laws and interpret the issues, who is right, who is wrong. Legislative is your parliament. Okay, parliament. And parliament's job is to make the laws. Okay, and executive is your police, your administrative authorities which implement the laws. So your administrative authorities, your police, etc. implement the law. So these are three important articles. Article 50 of the Constitution provides that the state shall take steps to separate the judiciary from the executive, because it is possible that the executive, the government, might try to interfere with the courts and the judge's opinion. So that you should take steps to separate and keep them, that the judges should not be influenced by what is the government in power. Okay. Okay, and proper steps should be taken that there is no concentration of power in hands of few, because if power comes in, then it becomes very difficult for anyone to object, because there is excessive power in few persons' hand. Okay, then it is not good for the country. Okay, the Constitution recognizes the effect of concept of equality between the three organs to keep proper checks and balances. So all these three organs should be kept independent and functioning proper, so that there is a proper checks and balance. Now coming to the law making process. In India, if you want to pass any law, it's very simple. You first have to introduce a bill. Okay, this bill will be introduced. It will be published in the official gazette. There will be a first reading, then there will be a committee, there will be a second reading, third reading. So ultimately it's a presentation of the bill. Then it will be built, it will be put in both the houses of the parliament. It has to be approved by both the houses of the parliament. Then the president's signature will come. Moment the president's sign comes, that then the bill becomes a law. At this stage, the bill will become the act. Companies bill becomes a Companies Act. GST bill becomes a GST Act. And now if you see, the direct tax code is there in line, in the pipeline. Once both the houses of the parliament approve it, and then you have the new direct tax code that will be applicable. Now coming to certain parliamentary committees. Okay, now what is these parliamentary committees? Through the parliament committees, the parliament exercises control and influence over the administration. They have salutary effect of the executive. The committees are not maintained to weaken the administration, instead to prevent misuse of the powers exercisable by the executive. Now let's understand what are these committees. The committees aid and assist the legislature in discharging its duties and relating to functions effectively, expeditiously, and efficiently. Let's simplify this. The parliament has a lot of committees and forms a lot of committees. On basis of these committees, the laws are passed. First, so they assist the legislature, because whenever the law is to be made, they have certain expert committees to guide them. Second, these expert committees prepare research reports and give it to the parliament and in the legislature, which will then used by the parliament to, and on basis of that various policy decisions will be made. Then comes ad hoc and standing committees. Ad hoc committees are on the spot committees that have been made. Ad hoc committees are appointed for a specific purpose. Okay, once the purpose is completed, the ad hoc committee will be dissolved. Okay, then comes standing committees. Standing committees are permanent and a regular committee which are constituted from time to time, and the work of these committee is of continuous nature. Ad hoc, from the name itself, it is on the spot, it is made for a certain purpose. Once the purpose is over, the committee will be dissolved. Standing committees are the throughout, it is there, it will have a regular functioning, and other committees can also be made for specific task. Then comes what is a bill. A bill is nothing but a draft statute which require approval of both the houses and the President of India. Then comes, there are different kinds of bills that can be introduced. One is your ordinary bill. These bills are concerned with any matters other than financial matters. So normally any company law etc. is a ordinary bill, because anything which is other than financial matter is a ordinary bill. When we talk about financial matters, these are called as money bills. Okay, money bills are under Article 110. Now, when I say money bill means what? Your money bill deals with any matter specified under Article 110. These are concerned with financial matters such as taxation. Money means what? Tax. Public expenditure is a specific kind of a financial bill. The bill is presented only in the Lok Sabha with the prior permission of the President. It is ratified by the Lok Sabha as a money bill. Now, what all are there in the money bill? Let's look. When I say about money means what? Taxes and expenditure. So when the government borrows money, so borrowings, the funds in the consolidated fund, contingency fund, appropriation of the money from where it will go, expenditures of the consolidated fund, and receiving into the consolidated funds and public accounts of India. So if I explain the budget, another word for the budget is called as annual financial statement. Annual financial statement. Okay, the budget has three parts. The budget always has three parts. One is the consolidated fund of India fund. Second is the contingency fund. Normally there is 500 crores kept in the contingency fund. Whenever there is a calamity etc., then the contingency fund can be used. And third is a public accounts. Public account. Now public accounts is where the government is acting as a trustee for all the pension. They are just keeping, where at some time they have to give it back to the people, to the employees etc. So example of this is when a salary is, from the salary they cut PF. At some time they have to return back on the retirement. So that is a public accounts. So that government cannot use it for its own self. Then coming to financial bills. Okay, financial bill is a wider scope. It not only talks about it includes a money bill. Financial bill, as the name suggests, concerns with the country's financial. It could be about taxes, expenditure, borrowings, revenues. So it covers all those matters which are there in money bill. It covers extra matters also, which are not covered in money bills. Okay, it has a more wider scope. All money bills are financial bills, but all financial bills are not money bills. For example, it also covers matters such as imposition of fines, penalties, etc. So in money bill we are talking about taxes. Here we are talking even money can come in from Not only taxes, but also when from fine is levied, even from there the revenue comes in. Then comes constitutional amendment bills. So whenever constitution is being amended under article 368, a constitutional amendment bill is passed. Okay. Then we talk about trade and commerce and intercourse in India. So article 301 deals with the freedom of trade, commerce and intercourse between the trade. So we'll see article 301 states that the trade, commerce and intercourse in the country shall be free throughout the country. So obviously we can do business. I can send my goods from Mumbai to Punjab to Tamil Nadu to Kerala to Jammu Kashmir. There is a freedom to do business. Also, any unlawful trade is not protected by article 301. Okay, if I want to deal in illegal drugs, etc. Object of 301. Article 301 has been included in the constitution to ensure that there is a unity of the nation. Okay, that there is a unity in the nation, that any state you can transfer the goods. By removing the geographical barriers and regionalism which exist in various parts of the country. Okay, then you come to article 302. Power of the parliament to impose restrictions on trade and commerce. So also parliament may impose restrictions on the trade, okay, between two states, etc. in public interest if it is needed. Then comes no discrimination between the states. So the parliament nor the legislature can discriminate between one or more states. Then comes article 304. Restrictions on the trade, commerce and intercourse. So the legislature of the state may impose on goods imported from other states any tax such as octroi or entry tax that they can levy, right? Then impose such reasonable restrictions as may be required in public interest. So here is very simple provision that in order to make the country united, we are ultimately made up of states. All states should be treated equally and business should be done freely. Then comes saving of the existing laws for state monopolies. Article 305. Nothing in 301 and 303 shall affect the powers of any existing law that when this constitution was made, insofar as the president may order or otherwise act. So unless the president has ordered, state monopolies will stay. So article 305 says that already formed laws providing for state monopolies. Article 305 can only do so unless president is not ordering something opposite to it. So that means they are saying save means what? Save all the laws which were talking about state monopoly unless the president has said don't or has stated otherwise. So state monopolies for whatever laws were passed will be valid. So we are done with the entire chapter along with all the past exam questions. So if I just take you through what exam questions have been asked. So they have asked about article 12, that is the definition of state and its powers. Then they have asked in the past, what are the restrictions on the freedom of speech and expression under article 19. So I told you 19.2 covers those parts. Then what is the procedure established by law? Okay, we've seen that. I told you article 14, 19, 21 very important, and writs. From here only the main question will be coming. Then article 19 again. Then came about article 14. Okay. Then came about the sound amplifiers, the example which I had given. Okay, doctrine of pith and substance has been asked. Then they have asked quo warranto. I told you writs, mandatory question. Article 14, 19, 20 and writs. One question is a sure question. Then comes doctrine of eclipse. We've done that also. Then comes article 19.1g. I told you article 19.1a and 19.1g are very important. Okay. Then that's it. So I have completed the full chapter marathon. Chapter of Constitution itself comes for around 15 marks in your exams, and I have covered it entirely in detail. Okay. Now do inform your friends, share it with your friends. Okay, and do like the video as well. Okay. Now let me go through your chat box questions. If you all want, you all can put up in the chats. I will read it up. So Utkarsh has said, okay, I want to ask you something. Please do ask me. Sir, I have never read about charges. Shall I go for your revision lecture? It is not a revision lecture. Whichever topics I'm taking, I take it in complete depth. I don't rush through anything. I take one chapter, but I go it in full depth. Okay. So you go for that charges chapter. You will see that everything is covered. Okay. You don't have to have basic knowledge also. I start from basics. Okay. Karthi, thank you so much. Renu, most valuable session. Thank you so much. Jyoti, thank you so much. Okay. So do inform your friends. Okay. Also about the channel, and tell them to join us in the WhatsApp or the Telegram groups, because there are these revision series. I want it to be, sent to almost everyone. Okay. I want to ensure that you will clear these exams. Okay. Thank you so much, Sony. Okay. Now, any other questions you all want to ask me apart from exams or any other things, also you can ask me. Okay. Or maybe if it's late, then maybe next time. So we wrap up. Sundari. Okay. Thank you so much. Okay, so don't worry, I will be coming up with more and more revision lectures till this December attempt. I want to ensure that I help you all to clear these exams. Okay, so that's it. And anytime you feel any need, you all are always free. You all can message me or put in the comment section also. I will take up those chapters which you all want. So I had earlier put up a Google form and I asked you all which chapters do you all want. On basis of that, I have been taking these lectures. Okay, so yes, I have earlier I used to teach both in Hindi and English, but then there are many students who were not getting any lectures in English, and I didn't want that they don't be able to clear these exams just because there are no channels. Okay, so then I took it up on myself to help them out, and I took it up in English. Yeah. So answer writing also we have taken up lectures on that, and Fatima ma'am has taken, she's got an all India rank. She's explained how to get those ranks. So I will put it in the, so you'll join the WhatsApp groups. I will send her video on writing, answer writing, how to write. Also second important point is, I have kept some test series. Check through the past videos how to give the test. You all write it. I'm getting it corrected for you all. Okay, so it's getting corrected, giving you all how you can write these answers, where you're going mistakes. So that will be even helpful. I'm even putting in the model answers in the app. Okay, so just go through the videos in past I've taken on how to write test. And GST also I will be taking. Okay, so don't worry. I will be taking up GST also, because GST for me is a cakewalk. I've written a book on it. In one go I can complete it. Okay, so I will be taking, don't worry. Okay, thank you so much for all of you all for being there till such late and your patience. Wish you all the very best. Thank you. Good night.